the notes and letters sent to the defendant. Exhibit CW1, letter which identifies the defendant as an employer and which introduces the defendant to ECS. Exhibit NSI EFMB2 is a letter indicating that as of 7th June 2022, the defendant had not registered what is this here? Instead, to do complied with the ECA. Exhibit NSI NMB3 MSBTE NB4 5 are the request letters, request letters, and including submission of payroll records and registration. My eyes are playing pranks here. However, Exhibit 6 and 7, marked as daily enforcement reports, provide significant insights into the nature of interaction between the claimant and the defendant. Exhibit CW6, dated 13th June 2022, records that upon visiting the defendant's office, claimant enforcement officers had a discussion with the director of the defendant's company, who is also a contact person. The director gave a future date, that is 16th June 2022, for them to return and finalize registration. Exhibit CW7, dated 6 June 2022, reveals that the scheduled registration did not take place as planned. The director was initially absent, and upon returning to the office, informed the claimant's officers that he had a hectic day and would call them later. This sequence of events shows that the defendant was not only aware of the claimant's visits and requests, sequence of events shows that the defendant was not only aware of the claimant's visits and requests, but had engaged with them, suggested a registration date, and later failed to follow through. In contrast, the defendant's counter affidavit claimed that it was unaware of evidence rebut claim of ignorance and establishes that the defendant had constructive and actual notice of its obligations. Furthermore, the defendant did not provide evidence of registration or any contribution made under the ECA. It also failed to rebut the existence or validity of claimant's statutory responsibility under the Act. Claimant posed 6 questions for determination and sought 6 principal relief. Shall now proceed to consider the questions seriatim and, where appropriate, jointly, as they raise related issues of statutory duty and regulatory compliance. Whether the defendant is an employer within the meaning of Section 73 of the Employees Compensation Act 2010. From Exhibit NSITFMB1 and the admission of the defendant's counter affidavit, the defendant is engaged in business or business operations and has employed more than 2 persons. Under Section 73 of the ECA, this qualifies as an employer, and so forth. Whether the defendant is under a legal obligation to make the mandatory monthly contribution to the employer's compensation fund since July 2011. Sections 33 to 35 of the ECA impose a legal duty on every employer to make contributions to the fund. The evidence before the court, especially Exhibit NSI TFMBI 1 to 5, demonstrates repeated notification and opportunities to comply. The defendant failed to refute these obligations with any contrary evidence. Question is also answered in the affirmative. As to whether the defendant is under a legal obligation to submit to the claimant records of wages and number of employees pursuant to sections 4 and 5 of the Act. It is submitted by the applicant or claimant that the obligation to furnish payroll and payments record is explicitly provided for in sections 4 and 5 of the Act. Exhibit S NSI TFMB2 reveals that the defendant did not provide these records during the compliance visit. The defendant did not show evidence of compliance as such. This question is answered in the affirmative. As to whether the claimant has the statutory power to inspect the premises of the defendant and obtain relevant documents and information as required by the Employees Compensation Act. Section 59 of the ECA grants inspectors from the NSA, NSAITFEB board the authority to enter and inspect employer premises and demand relevant information. Exhibits NSI TFMB 6 and 7 document such visits. The defendant did not deny that these visits occurred or challenge their legality. Accordingly, question is answered in the affirmative. As to whether the defendant is liable to pay penalty and interest for failure to remit contributions to the Employee Compensation Fund. Section 33 sub 4 of the ECA provides for the imposition of penalty and interest or defaulting employers on defaulting employers. Defendant has been in default since 2011, and there is no evidence of remission or exemption. Thus, the question is answered in the affirmative. In view of the foregoing, and having carefully considered the affidavit evidence, counter affidavit, documentary exhibits, and written submissions of counsel on both sides, the court is satisfied that the claimant has established its entitlement to the reliefs sought. The court finds that the defendant is indeed in breach of its statutory obligation under the Employees Compensation Act 2010. Accordingly, judgment is entered in favor of the claimant as follows. 1. It is hereby declared that the defendant is an employer within the meaning of Section 73 of the Employees Compensation Act 2010. 2. It is hereby declared that the defendant is under a legal obligation to make the mandatory monthly contribution to the Employees Compensation Fund from July 2011 to date. 3. It is hereby declared that the defendant is under a legal obligation to submit to the claimant all records of wages and number of employees as required by sections 4 and 5 of the Act. It is hereby declared, that's number 4, it is hereby declared that the claimant has the statutory right to inspect the premises of the defendant and obtain relevant documents and information from the defendant. 5. It is hereby declared that the defendant is liable to pay penalty and interest on the unremitted contributions to the fund in accordance with Section 33, sub 4 of the Act. 6. It is accordingly ordered compelling the defendant to pay the Employees Compensation Fund all outstanding mandatory contributions from July 2011 to date as assessed by the claimant. 7. It is ordered that the defendant submit all records of wages and number of employees to the claimant within 30 days of this judgment. 8. Claim of 2 million damages for the cost of this action is refused, there being no credible evidence in support thereof. This is the judgment of this court.
As the court pleases, we are most grateful, my lord.
Yeah. That will be all. Court will rise.
Court